Hello students, I welcome you once again to this class on business law. In this video, we will be looking into mistake, which is against free consent according to the Indian Contract Act 1872. So what is a mistake? Here I have mentioned that mistake is basically a misconception of something, or it is the misunderstanding of something, or someone mistakenly taking something as another. So mistake may be defined as an erroneous belief concerning something. So in this case, Mr. Raju mentions matter A to Mr. Shaju, but Mr. Shaju mistakes it as matter B. So there are different kinds of mistakes. Okay, so basically it is divided into two kinds, which are mistake of law and mistake of fact. So below mistake of law, we have of the country and of a foreign nation. And below mistake of fact, we have bilateral mistake and unilateral mistake. Below bilateral mistake, we have mistake as to the subject matter and mistake as to the possibility of performing the contract. And below mistake as to the subject matter, we have existence of the subject matter, identity, title, price, quantity, and quality. And below mistake as to the possibility of performing the contract, we have physical impossibility and legal impossibility. And below mistake of fact, we also had unilateral mistake. And so below unilateral mistake, we have mistake as to the person contracted with and mistake as to the nature of the contract. So mistake of law, we have two kinds, of the country and of a foreign nation. So of the country means to mistakenly take the Indian laws in the wrong sense. So if a mistake is regarding Indian laws, the rule is that the ignorance of the law is not a good excuse. Okay. So this means that the parties cannot simply claim that they were unaware of the laws. Secondly, of a foreign nation. So ignorance of a foreign law of any other country is not given a similar treatment. So ignorance of foreign law is given some leeway. Parties are not expected to know foreign legal provisions and their meanings. So a mistake of foreign law is in fact treated as a mistake of fact under the Indian Contract Act 1872. Mistake of fact. This is when both the parties misunderstand each other. Okay, so there was some error in understanding or ignorance or omission between the two parties. It is an innocent overlooking here. There is no intention of deceiving someone. So these mistakes can either be unilateral mistake or bilateral mistake. So when you talk about bilateral mistake, when both the parties to the contract are under a mistake of fact essential to that particular agreement, that mistake is called a bilateral mistake. Okay, here both the parties have not consented to the same thing in the same sense. So that is basically against free consent. So since there was an absence of consent, this agreement becomes void eventually. When you talk about unilateral mistake is when only one party to the contract is under a mistake. So in this case, the contract will not become void. We saw that mistake of fact is divided into two, bilateral mistake and unilateral mistake. So below bilateral mistake, we have mistake as to the subject matter and mistake as to the possibility of performing the contract. Below mistake as to the subject matter, we have six kinds. Firstly, we have existence of the subject matter, identity, title, price, quantity, and quality. So we'll see some examples on these cases. Firstly, existence of the subject matter. Mistake as to the existence of the subject matter. If both the parties believe that the subject matter of the contract is in existence, which in fact at the time of the contract is non-existent, the contract is void, or the contract becomes void. For example, there is an agreement between A and B for the purchase of a horse, but the horse is dead at the time of the contract. So this agreement becomes void. Secondly, mistake as to the identity. A mistake of both the parties in relation to the identity of the subject matter prevents a consensus ad idem and invalidates the agreement. For example, A agreed to buy from B 125 bales of cotton to arrive ex Peerless from Bombay, which is ship which is called ex Peerless. There were two ships of that name sailing from Bombay, one of which was in the mind of A and the other in the mind of B. So in this case, there was no contract formed. Thirdly, mistake as to the title, where the parties believe that the seller is the owner of the thing which he purports to sell, but in fact he has no title to it. The contract is void on the ground of mistake. For example, A agreed to take a lease of a fishery from B, though contrary to the belief of both parties at that time. A was tenant of the fishery and B never had any title to it, so the contract was void. Fourthly, mistake as to the price. The agreement is void when there is a mutual mistake as to the price of the subject matter. For example, there was a contract for lease between X and Y. The rent was inadvertently mentioned as rupees 130, though the agreement was to pay a rent of rupees 230. It was held that the contract was void. Fifth, mistake as to the quantity. So there is no contract between the parties if there is a difference between the quantity sold and purchased. For example, P wrote to H inquiring the price of rifles and suggested that he might buy as many as 50 rifles. On receipt of the information, he telegraphed, "Send 3 rifles," but because of the mistake of the telegraph authorities, the message was transmitted as "Send the rifles." H dispatched 50 rifles. It was held that there was no contract. Finally, mistake as to the quality. The agreement is void when there is a bilateral mistake as to the quality of the subject matter. For example, a contract for the sale of a horse believed to be a race horse would be void if it turned out to be a cart horse. So these are the kinds under mistake as to the subject matter. Next, mistake as to the possibility of performing the contract. So below possibility of performing the contract, we have physical impossibility and legal impossibility. Physical impossibility: a contract for the hiring of a room for witnessing the coronation procession was held to be void because, unknown to the parties, the procession had already been cancelled. Secondly, legal impossibility. A contract is void if it provides that something shall be done which cannot, as a matter of law, be done. So these are the types under bilateral mistake. Nextly, unilateral mistake, which is under mistake of fact. So in this case, we have two kinds: mistake as to the person contracted with and mistake as to the nature of the contract. Firstly, mistake as to the identity of the person contracted with, where A tends to contract with B, but by mistake enters into a contract with C, believing him to be B. The contract is void on the ground of mistake. Secondly, mistake as to the nature of the contract. A contract is void when one of the parties to it does not intend to enter into it, but through the fault of another and without any fault of his own makes a mistake as to the nature of the contract. For example, an old illiterate man was made to sign a bill of exchange by means of a false representation that it was a guarantee. So in this case, the contract became void. So thank you so much, students, for listening to this video. I hope this video would have been very helpful to you. Please subscribe to my channel and please do share this video with your friends. Thank you.